Hello, welcome to Legal Eyes, a podcast series that aims to keep our listeners informed of all sorts of developments in Canadian, particularly Albertan, law.
Hi, folks. I'm Brendan Thompson.
And I'm Barbara Dowker.
And we are lawyers at Gunn Law Group. And we're going to talk to you today about bail. Bail's been in the news a lot lately.
A lot.
And so we want to talk about what bail is and why you should or shouldn't care and what you should or shouldn't believe as well.
I feel like bail is a very contentious issue with the public because a lot of news media often will report on big cases where an individual was out on bail and they committed a very serious violent offense.
Yeah. So let's talk about what bail is, because I think that there's a tendency to think that, the police catch somebody and then they just let them go on bail and that's the end of it. They're done. They never have to come back to court. But what is the point of bail? What is it actually? Do they have to come back to court?
They do. So if you are arrested by the police and you are essentially let go, either by a police officer or at the justice of the peace level, you are required to return back to court. Depending on the case, sometimes it's within a week, sometimes it's the next day, or it could be 3 weeks away, but you are required to come back to court.
Right. Okay. And so bail then is just a temporary release until your case is resolved somehow.
Right. So there's a presumption of innocence in Canada under law that you have to be tried in court by the Crown prosecutor beyond a reasonable doubt that you've committed whatever is being alleged that you did. And because of that presumption of innocence, oftentimes it would be unfair to keep an individual in custody at a remand center while they await their trial.
Right, because maybe they go to trial and at the end they're found not guilty, and then they just spent however long it is until trial, 6 months, depending on a year.
6 months, a year,
Yeah.
2 years.
Right.
2 years of their life could be wasted in jail on charges that the Crown couldn't prove the case on.
Right. Okay.
So bail is essentially you promising to the court that you're going to follow conditions. So you're not just free to do whatever you want, free to go wherever you want, but you're going to be following conditions in exchange for not being held in a remand center.
Right. Okay. So something that comes up that I see is that people are to be let out on the least onerous conditions. And so I think that it's important to note, first and foremost, that it's the least onerous for that person in that case, right? It's not just no conditions at all. It's we look at the case and specifically decide what are the least onerous conditions that would protect the public in this situation. So when we're looking at what the least onerous conditions are, and a judge is determining, am I going to let this person go or not? What are the things that a judge has to look at? Or what are the criteria that they go over?
Well, there's 3 grounds when it comes to bail. There's primary grounds, secondary grounds, and tertiary grounds. The primary grounds are, will this person come back to court? If I release this person, are they likely to come back and appear at their next court appearance, or should they be remanded? Because every time we do give them a court appearance, they never come back.
And is there a way to tell if somebody has not shown up at court before?
Yeah, so typically if an accused person doesn't attend their docket appearance or their trial or whatever court appearance they're required to do, they will receive another charge, which is called a failure to appear in court. And unless you have a very, very good excuse, you will be found guilty of that because the court is
Right.
essentially has documentation that you did not come. And that can add up pretty quickly on a criminal record. So if someone has several failure to appears on their criminal record, it's a good indicator to the court that this is not someone that can be trusted on their word to come to court later.
Right. Okay. You said there are primary, secondary, and tertiary. What's the secondary grounds?
Secondary grounds is considering, will this person likely commit crimes while on release. So again, this is reserved for people who have criminal records, violent criminal records. If someone has a history on their criminal record of committing assaults, and here they are before the court again committing assaults, well, the court will have a hard time justifying letting them out into the community if they have a history of doing those types of things. It's also a balance of keeping the complainant safe as well. Is there somewhere else this person can go? Can they stay away from the complainant or the area or whatever they're alleged of doing? And if they can, that kind of addresses secondary grounds. But if they can't, that plays a big role as well.
Right. And then what about the tertiary grounds?
Well, the tertiary grounds is kind of a funny area of law because it's basically about whether the public would, a reasonably informed person of the public would be distraught or disappointed or feel as though the justice system is failing by letting out this person. So it tends to be about the strength of the Crown's case. It tends to be about whether a general person in the public hearing this would be appalled, and these bail conditions don't address proper safety of the public.
What do you mean the strength of the Crown's case? How can you assess the strength of the Crown's case before a trial or at a bail hearing, say? We're in the courtroom. There's a judge sitting up there. We've got a prosecutor saying, let's keep this person in jail. We've got a defense lawyer saying, no, let them out. How is a judge looking at the Crown's case in that?
So it's kind of difficult and case by case dependent. That's why I kind of chuckled at the tertiary ground, because it's difficult to judge. So lots of times at bail hearings, the Crown will read a summary of what the allegations are. And this isn't taken as evidence, like the Crown isn't calling evidence. This isn't seen as evidence before the court. This is just to give the court a background of why we're here. And if those allegations logically come with expectations that the evidence will likely be able to be reproduced at trial, that suggests to the court that there's a very strong case here. And if it's something quite serious, a very violent offense, then the court will say, well, if you're found guilty of this, you would be thrown in jail for a long period of time.
Right.
Therefore,
we think the Crown's case is strong.
We think the Crown's case is strong. And the Crown will likely be able to prove this, therefore remanded.
Right. Yeah. Well, let's talk about that a little bit, because I want to go over how much time someone will spend in jail before trial versus after trial, because I think there's a feeling, or it seems to me that there might be a feeling that, you know, we're letting these people go on bail and they might not be spending as much time in jail as they should, or something like that. So does being released on bail change how much time you're going to spend in custody?
No, not at all. So if you're released on bail and ultimately you're charged with a serious offense and the Crown can prove that offense, you will be going back to jail and you will serve as if your bail conditions essentially don't matter. You're going back to jail and serving the full sentence. Where if you are remanded until your trial and you're found guilty at trial, you are actually credited 1.5 days to every 1 day that you spent in the remand, just because of the conditions of the remand.
You're credited time and a half. Now, so if someone could be out, there's many reasons, I guess, why someone could be out of jail when they could otherwise be in jail. So I'm thinking about things like parole versus bail versus probation, or, I don't know, a conditional sentence order or something like that. What's the difference between bail and one of those other things?
So bail is something that happens before you're found guilty, and that's why bail is such a prominent part of the law. Again, circling back to that innocent until proven guilty, bail is suggesting that you can live in the community because at this point you're still innocent. Where all of those things, probation, parole, a conditional sentence order, those are all types of releases from jail after you've been found guilty and you're serving part of your sentence in the community.
Right.
Those sentences are typically looked at rehabilitative aspects. So if you are on parole or probation, there is some sort of correctional overlord supervising you.
Right. Yeah. Okay. So something that I want to mention is the importance of bail in making sure that somebody doesn't plead guilty basically just to get out of jail, right? And that, I think, is one of the most important aspects of bail, because when somebody's in jail and they want out, they'll say almost anything to just get out of jail. And so if someone says, well, if you plead guilty, we'll let you out now, chances are that person's going to plead guilty. And they're not necessarily going to think about, well, what is the impact on my future, and what is the impact on, I don't know, the criminal record? Did they actually do it? Are people going to think of them differently if they admitted to doing this? So bail is a way to make sure that we're keeping the justice system honest.
Yeah, absolutely.
Yeah. So there's some sort of recent instances of bail being discussed in the news. And I wanted to go over a couple of those instances with you to see, what we make of them. There have been cases, I guess, about someone who's accused of murder, which is the most serious crime in the criminal code.
Offending the Queen's pretty serious.
Well, I bet those people get bail too. So if someone's been charged of murder, why is it that they might get bail? Like, surely we don't want the murderers roaming the streets.
Correct. And
there are lots of things to consider.
Thank you. There's lots of things to consider when, looking at whether someone accused of murder or manslaughter can be released. One of the most important aspects is it's actually reverse onus. So the accused actually has to prove to the court on a balance of probabilities that they would actually be safe to be released into the community, which is something that a lot of other cases don't have. Most of the time, if you're a first-time offender charged with an offense, it's the Crown prosecutor's onus to prove why you should be kept in custody. But with murder and manslaughter, you actually have to prove to the court. And it can't just be heard at any level of court like all other charges in the criminal code are. You actually have to secure a date in front of a King's Bench judge or justice at a superior court level. So it can't just be heard in regular provincial docket court or at the JP level. And that can take some time. So there are some serious safeguards. I would say it would be very rare that someone charged with murder would be released automatically.
Right.
There requires some litigation back and forth, even if the Crown is ultimately consenting to that person's release. It definitely requires some litigation back and forth.
Yeah. And so, again, they have to go back and consider all those factors that we talked about at the beginning. Is this person going to show up to court? Is this person a danger to the community in some way? And can we demonstrate that the conditions that they're going to be released on keep them from being a danger or keep them from presenting a danger to the community? So there's one case, I think, that was also in the news recently where there was a police officer who was charged with murder. He got bail the day after he was arrested.
Yeah.
And so you mentioned that there's usually a little bit of back and forth on these sorts of things. So is a day after you've been arrested for a murder charge getting bail, is that out of the ordinary? Very
much, in my opinion. I don't know that anyone ever has it before, but I stand to be corrected. Usually it takes weeks, if not months, to get in front of a King's Bench justice and speak to bail. So
right.
It is shocking that was able to happen so fast, but presumption of innocence, I guess. And
yeah. Which, I mean, if someone's able to do it and there's a defense lawyer out there able to get their client before a King's Bench justice in a day, I guess that defense lawyer is doing good work.
Yeah, I would say the defense lawyer did very good work there. But I do want to keep in mind that it's important that there does not become two tiers of justice for those
right.
who have money and for those who don't.
Yeah.
And so while I commend that defense lawyer, and I think he did everything right and did excellent work for his client, we have to keep in mind that there are others that don't have those types of resources. Mm-hmm. And it shouldn't necessarily be special treatment for some, not others.
Yeah. What about crimes that are committed while someone is out on bail? Certainly, the media seems to suggest that is an epidemic, that is a huge problem, and we need to be much tougher on bail than the criminal code already is. So that's a hard one to talk about because like you and I can only talk about bail basically anecdotally. Like we're not going to break out our stats or something like that.
No.
We don't. I mean, I don't keep stats on the bail hearings I've run. But when it comes to someone committing a crime while they're out on bail, does that demonstrate that there's a problem with how bail works? Could it?
That's a very heavy question.
Yeah.
And a good question at that. I don't know. I mean, the system that we have right now is that if you do commit a crime while you're out on bail, there are several things the prosecutor can do, one being revoking your previous release.
Right.
So any sort of release you had prior gets revoked and you have to run a bail hearing on everything again. But also it becomes reverse onus on the accused. So the accused is now alleged to commit multiple crimes and they have to show why they are released. But I don't know. It's difficult because human behavior isn't straightforward.
Yeah. Sometimes
You see clients who've had a terrible criminal history do well on bail, and sometimes you're surprised about who cannot follow a bail plan. What do you think, Brendan?
Well, I think that part of the problem with repeat offenders is that repeat offenders, certain people that for whatever reason, whatever problem they have in their background, or whatever character flaw or something that they have, they commit lots of crimes. And I'm not sure that it's really a good metric to say, well, they committed this crime on bail and therefore there's a problem with bail. It seems to me that the problem might be the fact that we don't do anything to really address repeat offenders and what it is that is causing whatever it is that leads them to commit more crimes.
That's such a good point.
Going to get out of jail, not just bail, like after jail, and I think that's an important point, is that jail ends eventually, right? Like people get out.
Jail ends eventually, even for murder clients.
Yeah.
It might be 25 years that they're stuck in jail or 50 years, but they do get out eventually.
Yeah.
And
they might commit more crimes, which most jail sentences are far shorter than a murder sentence.
Far shorter.
Just like, murder being the very far end of the spectrum. Most stuff is like, 30, 60 days, and those are, pretty short sentences. But people are going to get out of jail after that, and they very well might just do something else.
Yeah, I think you hit the nail on the head that bail, the system that we have for bail right now is not necessarily problematic. It's not necessarily something that doesn't work. It's poverty, it's mental health, it's colonization, it's just essentially the deep-rooted issues in society that are not necessarily addressed.
Yeah, there's not really a system. I mean, we look at, here are the primary, secondary, and tertiary grounds to make sure that this person is out okay on bail and they're being properly supervised in the community and so on. But then once somebody's sentence is over, whether that's probation or jail time or whatever, there's no guideline or anything to make sure that they still have the proper supports in place to continue on whatever path. If they set off onto a good path, there's nothing in place to keep them going that direction. And so from my perspective anyway, it's not really a problem with bail itself. It's a problem with how do we address why this person is committing crimes, which maybe bail conditions can sometimes address. Sometimes they can't. And obviously, I guess if they can't, then we're getting into repeat offenses and reverse onus situations.
Mm-hmm. And the remand centers aren't empty. They are quite full.
Yeah.
They are quite full. And so it's not necessarily an easy thing to get bail. Lots of times, a lot of work goes into that. And whether it be going to treatment or setting up housing, so sometimes those issues that are causing someone to offend are addressed with a bail plan. And they succeed.
Right. So what do you mean? So when you say a bail plan, and you say, like, we're trying to address these issues. As a lawyer, because you help your clients make bail plans, what does that mean and what does that look like to you?
It's essentially what they're going to do with their time if they were released. Where are they going to live? What are the conditions that they're going to follow? What are they being allowed to do versus not allowed to do? Where are they allowed to go versus not allowed to go? And it has to be an agreement with the accused that is workable, that satisfies those 3 grounds and addresses the fact that the public will be safe if we allow them to go do these things. A lot of times, clients are released with a curfew where they have to be in a residence or a house arrest. And the police have full support from the court, and it is often a condition of the release that the police go and check and make sure that they're following those conditions. And if they're not, the police find it pretty quickly, I say.
Yeah, for sure. And so then they presumably get arrested, they get brought back to court. And if the Crown revokes their bail, they're in a reverse onus situation. Is something that I am aware of, I guess, just knowing about bail, is that conditions can get more and more restrictive. And so what is that? How do we judge how restrictive a condition is? Like, how do we know, how do we choose the conditions, and how do they get more restrictive as we go, as someone has these successive releases?
I would say, it's hard to pinpoint. It's very case dependent and it's very person dependent. Probably if we're talking about someone who has not committed murder or serious sexual assault or any of those big offenses, but is, let's say, in for property crimes or that type of thing, they'll be released on conditions, maybe not to go somewhere or not to, drive a vehicle or those types of things. But if that person seems like they can't even follow those strict conditions, there needs to be a step up.
Right.
And there needs to be more conditions put in place to supervise them. And that's where a curfew might come in, or a house arrest might come in, or they have to put up money to be released to hold them. And then the final kind of rung on the ladder is what's called a surety. And what a surety is you have someone, a friend or family member, be your jailer in the community. So they're essentially responsible for you to make sure you're following your conditions, and are actually required under law to call the police or your probation officer if you do commit an offense. So it's quite a strict level of supervision. And not anybody can be a surety. They actually have to go through quite an involved process. They have to get independent legal advice from a lawyer. They have to swear documents. Sometimes they even have to testify and are even cross-examined by Crown prosecutors in court to see if they're able to supervise these people. It's not just anybody who walks in on the street can be a surety. It's a bit of an involved process. So that's what I see. What do you think, Brendan?
Well, no, I think that's right. That's kind of what I was getting at, is if somebody has been accused of another crime while they're out on bail, then the judge is going to look at that and go, okay, well, we obviously need to make the conditions stricter. And that's something that's been in the criminal code for, ages. And the changes to the criminal code, even in the last 10 years, haven't really changed that. So when we talk about people being out on bail and committing more crimes, there are things in the code and there are things in the justice system that are designed to address that. I think that has given us a pretty good understanding about bail and conditions and, who can get it, who can't, what are the situations and circumstances that might lead to getting bail.
Yeah.
Just as a caveat at the end of this, nothing in this podcast is legal advice. If you need to know about bail because you yourself need it or someone you know needs it, then you should call a lawyer. And maybe that's a lawyer at Gunn Law Group, or maybe it's a lawyer somewhere else. But hopefully it's a lawyer in the jurisdiction that person needs bail out of.
This is just general information about bail.
Yeah. There is nothing in here that you should rely on as legal advice. Other than that,
thanks for talking to me about bail today, Brendan.
Yeah, thanks, Barbara. This has been fun.
Yeah.
And I hope that the folks listening have gotten a little bit of a better idea about what bail is and why we care.
Thanks.
Thanks, folks.